Hi everyone, good afternoon, and thank you for joining us in our 2024 complimentary webinar series covering the FAR, or Federal Acquisition Regulations. We are coming to you live today from Washington, D.C., and we're glad you all could make it. Okay, so a bit about this series. As usual, all of our webinars are complimentary and recorded. The FAR has 52 total parts, and we will run through them sequentially each week on Wednesdays and Fridays at noon Eastern Time. The recordings and PowerPoints will be posted within 24 hours of the webinar's ending. You can find the recordings on our YouTube channel simply by subscribing to it using the link you see on the screen. There is no cost. You can find the PowerPoint on the SlideShare site using your LinkedIn credentials to log in. Again, it is free. We also offer sponsorship opportunities. If you are interested, please send us an email to hello@jenniferschaus.com. And now for how to sign up for this series. Unfortunately, there's no bulk registration. You must register individually for each webinar. If you go to the Jennifer Schaus website, navigate to the section called the FAR, and you'll find the individual registration links. Also, the recording links will be posted here upon the completion of each webinar. Please note we covered the FAR in 2020, so if you are eager to get a jump start, please find these historical recordings on our site. Navigate to the Webinars tab and scroll down to the section, the FAR 2020. Please note that because it has been 4 years, many of the regulations have changed and been updated, so please use this as a reference tool only. And now a bit about us. We work with established federal contractors worldwide, helping them to navigate the market. Our services range from market analysis reports to contract vehicles and compliance. Some of the contract vehicles we support are listed here on your screen. For more information, please visit our website. Those are our services for federal contractors, but we also provide marketing and advertising services for organizations who are selling to federal contractors. We can add extra muscle to your marketing efforts via our newsletter ads and webinar sponsorship to in-person events. Please email us and ask for a media kit if you are interested. We are currently offering a discounted offer in our newsletter, which reaches over 30.6 thousand subscribers. If you want to place an order or have any questions, please send us an email to hello@jenniferschaus.com. Contract vehicles can be great marketing tools for pursuing federal business. Current open solicitations include Navy Seaport, Next Generation, and NASA, as well as GSA Alliant. Additionally, the GSA Multiple Award Schedule is an open and rolling RFP. If you qualify for any of these and need proposal support, please email us for a quote. As you know, congressional hearings on both the House of Representatives and on the Senate side are open to the public unless otherwise stated. We have a list here of the upcoming schedule, including the date, time, building, and room numbers. Most meetings take place in the Dirksen, Rayburn, or Cannon buildings. If you are selling to any of these departments or agencies, attending these hearings can be a great way to gather information, understand the process, and also network with influencers. Please join us for these upcoming complimentary webinars with various Apex accelerators. Jennifer will be covering GSA schedules as well as federal marketing for our local Apex Accelerator in Virginia. These are complimentary and online webinars. Please join us. She will also be teaching 2 classes for the Maryland Apex Accelerator, one on marketing and one on GSA schedules, which are in July and in December, and once again, complimentary. Coming up these next 2 weeks, we will hear from Carrie Palmatier on small business innovation and federal contracting. Specifically, Carrie will cover information on SBIRs and STTRs. These 2 options are a great way for tech companies to grow in the federal sector. This is a 2-part series. As always, these are recorded and complimentary. Please join us and over 300 government contractors on Monday, June 24th at the Kennedy Center for our Federal Government Contractor Summer Soiree. Firstly, we want to thank our event partner Bitspeed and also our sponsors Capital Bank, RXO, GovSpend, Federal Compass, Fully Promoted, Sandy Spring Bank, At Work, and Caltech. Additionally, we want to thank our in-kind sponsors, the Virginia Apex Accelerator and Nova Hispanic Chamber. You'll be able to meet with the federal government, including the SBA, USAID, NSF, NAVC, NAVAIR, U.S. Air Force, the Army, HHS, and the VA. So please register in advance to attend. Our webinars are complimentary thanks to our longtime and generous corporate and in-kind sponsors. Please allow me to introduce them. We would like to thank our friends at GovEvents, the premier platform for posting events related to the government and government contracting. You can find all of our webinars and our events on govevents.com, as well as recordings from our past 600+ webinars. We also want to thank Tom Johnson and his team at Set Aside Alert, the go-to publication for contracting opportunities for small, woman-owned, veteran-owned, HubZone, and 8A firms. Visit setasidealert.com for more information. The Fairfax Economic Development Authority has an online calendar of events and webinars. We want to thank them for posting our events and webinars on their calendar. Join the Greater Reston Chamber of Commerce's monthly GovCon Council meeting to network with peers, learn about upcoming events and opportunities, and help to shape future programming. The meetings take place the fourth Tuesday of each month at 8:30 a.m. at the Greater Reston Chamber of Commerce. The next meeting will be on June 25th. Do you need help winning government contracts? Bitsby can help. Users can find contract opportunities from federal, state, and local government. Additionally, you can search for teaming partners, incumbent point of contact, expiring contracts, compliance matrices, and also proposal templates. Create your login today at bitspeed.com. Bitspeed is an official partner of the U.S. Small Business Administration's E2G and Power to Grow program. Events are the ultimate engagement channel to bring government and industry together. 68% of government personnel report that they attend more than one event each year. The Federal Business Council, or FBC, has worked with government and industry for 45+ years to create gatherings where ideas are shared and to help government achieve its goals. This includes agency industry days, cybersecurity symposiums, technology expos, and offsite meetings. The FBC provides full lifecycle meeting planning and event management. With over 5,000 meetings under their belt, FBC has experienced systems and personnel to make your next event exceptional. Learn more at www.fbcinc.com. Now, last but not least, please check out our friends over at GovBrew. GovBrew is the most read GovCon newsletter, keeping thousands of GovCon professionals in the loop with news, updates, and opportunities in the federal contracting market, all in a fun and accessible email that only takes 5 minutes to read, and it's 100% free. It goes out every Monday, Wednesday, and Friday at 7 a.m., and it's filled with content, event postings, webinars, and more. We encourage you to sign up at govbrew.co, or you can use the QR code you see on the screen. And now the reason we're here today is to cover FAR Part 41, Acquisition of Utility Services. Please welcome William Stowe to the webinar. William, we're so glad to have you here with us today and are excited to hear your presentation. I'll put myself on mute and turn the floor over to you.
Thank you. As she said, my name is William Stowe. I'm an attorney at Jackson Walker. I'm based in our Houston office. I am the chair of our firm's government contracts and procurement section, and I am a commercial litigator, but I also practice government contracts and procurement. I'm a member of the Court of Federal Claims. I assist clients at every level of procurement, federal, state, and local, and at throughout the course of a procurement, from negotiations, bid preparation, understanding the FAR and the DFARs, and bid protests, contract performance issues, you name it, I'm able to assist. Next slide, please. So today we're going to be talking about Part 41, which has to do with the federal government's acquisition of utility services. And here I'm providing just an overall outline of what we're going to talk about. First, we're going to talk about applicability of Part 41, what triggers it, what it does not apply to. A lot of that depends on Part 2, which is of the session, which is definitions. What is a utility service and other related definitions. Third, we're going to talk about who runs the acquisition of utility services. It's primarily GSA, but it delegates authority, and we're going to talk about how that works. Fourth, we're going to talk about the nuts and bolts of acquiring utility services by the federal government. Fifth, we're going to talk about requests for assistance from GSA. And there's a subsection in Part 41 that allows GSA, even when it's delegated authority to various federal agencies to acquire utility services, to provide assistance. Sixth, we're going to talk about administrative issues relating to monthly and annual reviews, rate changes, and the all-important intervention in state regulatory body proceedings relating to rate changes. Seventh, we're going to talk about solicitation provisions and contract clauses that are required to be included. And eighth, we'll briefly go over the forms and formats that have to be used. Next slide, please. So for Part 1, for the first section, we're going to talk about applicability. So the general rule is that Part 41 applies to the acquisition of utility services, and that's a defined term for the government, including connection charges and termination liabilities. Each of those terms is defined, but it does not apply to various acquisitions. For example, it doesn't apply to utilities produced, distributed, or sold by another federal agency, that requires use of interagency agreements. It also does not apply to utility services obtained by purchase, exchange, or otherwise by a federal power or water marketing agency incident to that agency's marketing or distribution program. It also doesn't apply to telecommunication services. Some people might think that or would consider that, a lay person might consider that to be utility. Well, it's not for purposes of Part 41 or cable television. It doesn't apply to acquisition of natural manufactured gas when purchased as a commodity. And we're going to see some distinctions between commodities and distribution systems in a bit. It also doesn't apply to acquisition of utilities in foreign countries. Next slide, please. Nor does it apply to acquisition of rights and real property and various public utility facilities, on-site equipment, etc. It also doesn't apply to third-party finance shared saving projects authorized by 42 U.S.C. 8287. Although, and we'll see this later a bit more as well, agencies can still use optionally Part 41 for energy savings or purchased utility service directly resulting from implementation of a third-party finance shared savings project under a specific code provision. And it's for periods not to exceed 25 years. Next slide, please. So we looked earlier at the general rule. It applies to the acquisition of utility services, and that includes connection charges and termination liability. So we have to understand what that means. Well, it's defined in Part 41, utility services, to mean a service such as, and that's important, it says such as, furnishing electricity, natural or manufactured gas, water, sewage, thermal energy, chilled water, steam, hot water, or high temperature hot water. The application of Part 41 to other services, e.g., for example, rubbish removal, snow removal, may be appropriate when the acquisition is not subject to the 41 U.S.C. Chapter 67 Service Contract Labor Standards, which you can see at FAR 37.107. So the point here is it gives you a definition, but it's a rather broad definition, and it's not all inclusive. There may be other services that, and it gives a few examples, but it's not all inclusive, where Part 41 may be used to apply to the acquisition where it's not governed by the Service Contract Labor Standards. Next slide, please. So the other two definitions, recall utility services includes these other two items. Connection charges, the FAR Part 41 defines them to mean all non-recurring costs, whether refundable or non-refundable, to be paid by the government to the utility supplier for the required connecting facilities, which are installed, owned, operated, and maintained by the utility supplier. It gives a cross-reference to termination liability, which it defines to mean a contingent government obligation to pay a utility supplier the unamortized portion of a connection charge and any other applicable non-refundable service charge as defined in the contract in the event the government terminates before the cost of connection facilities has been recovered. Next slide, please. So we know it applies to utility services. We've now seen the definition of what that means and what it does not apply to. So who's responsible for the acquisition? Well, under Part 41, GSA is generally the entity that does all of the acquiring of utility services for the federal government. The general authorization, both statutory and regulatory under the FAR, is that it is authorized to contract utility services for periods not exceeding 10 years, and it's authorized to prescribe policies and methods governing acquisition and supply of utility services for other federal agencies. And related functions, including, and we'll talk about this later, appearing itself, GSA appearing before state and federal regulatory bodies. I say generally GSA because there's also statutory and regulatory authority for other specific agencies within the federal government to acquire utility services. These include DOD and DOE. And note, by the way, that when the Department of Energy itself acquires utility services, it has this extra provision in there about when it acquires electric services for periods not exceeding 25 years, but only for uranium enrichment installations. So there's a bit of a carve out there. But perhaps most importantly, while GSA is generally the top dog when it comes to acquiring utility services, it can delegate its authority to various federal agencies, including DOD and DOE. But it can delegate its authority to acquire utility services to any federal agency. But even if it does so, which it often does, it will, as necessary, conduct review of the acquisitions. Next slide, please. So requests for delegations, dovetailing onto that point about GSA delegating the authority to acquire these utility services, it's not just a free-for-all. The agency has to submit a request for each acquisition of utility services, and it has to prove that it's capable of doing so. This is not just a, for those of you who've seen state and local procurement delegations of authority, this isn't just a handoff. There has to be an established ability to acquire it within the procedures and policies governed by federal law, including the FAR. Next slide, please. So we're now going to move to just the nuts and bolts of acquiring utility services. And we're first going to talk about the policy, the general policies. And it says in FAR 41.201A that subject to paragraph D of this section, and that's incredibly important, it's the policy of the federal government that agencies obtain required utility services from sources of supply which are most advantageous to the government in terms of economy, efficiency, reliability, or service. So it provides a general standard there, most advantageous to the government, given economy, efficiency, reliability, or service. But it's got that huge qualifier in the beginning. So what are those caveats in paragraph D? Well, the first and perhaps most important of the caveats stems from a rather old statute or act, which is the Appropriations Act from '88, that provides that none of the funds may be used for the purchase of electricity by the government in any manner that is inconsistent with state law governing the providing of electric utility service, including state utility commission rulings and electric utility franchises or service territories established pursuant to state statute, regulation, or approved territorial agreements. And this is incredibly important because what they are saying here is that may be the general standard up there, the most advantageous given economy, efficiency, reliability, service, but you can't use, the agencies can't use the funds to procure electricity in any manner that is inconsistent with state law. It's conceding power over to state regulatory bodies with this concession. Next slide, please. And with that concession, I will note that there is a little bit of case law on this, and one court, the Baltimore Gas and Electric Company versus the United States, held that concession, that provision that says you got to look to state law and it can't be inconsistent with state law, that pointing to state law does not apply to the purchase of electricity distribution services, as opposed to the purchase of the commodity of electricity. So if state law would say something about electricity distribution services, according to the court in this case, Baltimore Gas and Electric Company, that provision does not necessarily mean that the acquiring federal agency has to give credence or deference to the otherwise inconsistent state law. Next slide, please. Other caveats to that general policy on most advantageous, there are several. I won't read them in detail here, but there are shared energy savings programs and contracts that are not precluded by the act that is referenced, the act being the Defense Appropriations Act, and there are other acquisitions by military departments that caveats are provided. Next slide, please. An additional caveat is that, and note here, this is again is referencing state law. It says that agencies, acquiring agencies, may, consistent with applicable state law, enter into contracts for the purchase or transfer of electricity to the agency by a non-utility, including a qualifying facility under the Public Utility Regulatory Policies Act of '78. It also makes clear that they can enter into interagency agreements pursuant to the relevant FARs and a Federal Power Marketing Agency or the TVA for the transfer of electric power to the acquiring federal agency. And they can enter into a contract with an electric utility under the authority or tariffs of FERC. Next slide, please. Another important policy, in addition to the most advantageous general policy, subject to those important caveats, is that except for acquisitions at or below the simplified acquisition threshold, which I note below is currently $250,000 with some variations, agencies shall acquire utility services by a bilateral written contract, which must include the clauses required by 41.501. And it goes on to state that agencies may not use the utility supplier's forms and clauses to avoid the inclusion of provisions and clauses required by FAR 41.501 or by statute. So the gist of this, although we're going to see something that conflicts with it a bit later, the gist of it is the agency can't use the utility supplier's own forms to negate or neglect to include the required clauses that are set forth in the FAR, specifically FAR 41.501. Next slide, please. So what we see here, though, is a bit of some counterintuitive policies relating to competition. As anybody who's familiar with the FAR knows, and really government contracting generally, even at the state and local level, competition is the general rule of thumb in this country. It runs rampant throughout the FAR and in state and local procurement. Yet, when it comes to acquisition of public utility services by federal agencies, we see something a bit different. In FAR 41.201E, it says, prior to acquiring electric utility services on a competitive basis, the contracting officer shall determine, with the advice of legal counsel, by a market survey or any other appropriate means, for example, consultation with the state agency responsible for regulating public utilities, that such competition would not be inconsistent with state law governing the provision of electric utility services, including state utility commission rulings and electric utility franchises or service territories established pursuant to a rule, a statute, or an agreement. Why is this so important? Because the general rule of thumb is competitive procurements, but this is saying they can't even do that without first determining that doing so would not be inconsistent with state law. And as many of you know, state law often precludes competition in the area of electric utility supply, whether directly or indirectly. So this is an enormous, again, concession to state law, and not just state law, but competition, whether or not you're even going to have competition when the federal agencies procure utility services. Next slide, please. So what are the nuts and the bolts? We've discussed now the policies of acquiring utility services by federal agencies. What are the nuts and the bolts of the actual procedure? Well, the contracting officer has to comply with Part 6 and 7 and 41.201 D and E, which we discussed previously. In Part 6 and 7, it has to conduct a market survey and perform acquisition planning in order to promote and provide for full and open competition, provided that the contracting officer determines that any resultant contract would not be inconsistent with applicable state law governing the provision of electric utility services. Again, a deference to state law. So what does the market survey entail? If competition for the entire utility service is not available, the market survey may be used to determine availability of competitive sources for certain portions of the requirement. The scope of the term entire utility service includes the provision of the utility service capacity, energy, water, sewage, transportation, standby or backup service, transmission and or distribution service, and the other items listed. The market survey itself must consider what we're going to get into are the three general ways of procuring. So you begin with this market survey process, and this needs to include considering GSA area-wide contracts, which we're going to talk about, alternatively separate contracts, or thirdly interagency agreements. Next slide, please. So we talked earlier about how you cannot use a supplier's forms to avoid required contract clauses. Interestingly though, the FAR in Part 41 provides for a scenario in which a utility supplier refuses to execute a tendered contract, a contract tendered by the federal agency that includes those required clauses. And it says that in that event, the agency shall obtain a written, definite, and final refusal signed by a corporate officer or other responsible official of the supplier, or if unobtainable, document any unwritten refusal, and transmit this document along with statements of the reasons for the refusal and the record of negotiations to GSA at the address specified in a separate FAR part or subsection. And it says, unless urgent and compelling circumstances exist, the contracting officer shall notify GSA prior to acquiring utility services without executing a tendered contract. So it's setting us up here for being able to obtain the utility services without getting an executed tendered contract. And it does indeed go on to say, after such notification, the agency may proceed with the acquisition and pay for the utility service provisions of 31 USC 1501A8 and do it by a purchase order and paying for it upon presentation of an invoice. And this is truly remarkable because it's basically, the FAR is telling us that, yeah, we are requiring certain contract provisions listed in the FAR to be included. But if the supplier just refuses to sign the tendered contract, we sort of recognize you need utilities, so you can just obtain it anyway. Next slide, please. Of course, you have to document that refusal. And in addition, it says that if this occurs, this scenario occurs, the CO, the contracting officer, must establish a utility history file, which has to contain, in addition to various documents, information that the FAR sets forth, and you can look at that on your own. But it's basically due diligence. They're trying to fix it so that people don't take shortcuts here in not executing bilateral written contracts that include the required contract clauses that is required by the FAR. So this, again, this is remarkable because if you know anything about the FAR, getting a federal agency to agree to not include required contract clauses is near impossible. But the FAR, in this instance, acquisition of utility services, actually allows it if the certain circumstances apply. I list here, I say no subterfuge. Obviously, nobody should be trying to do some sort of shortcut or side deal with the contracting officer with a wink, wink, nod, nod that, hey, just give me a refusal to sign the tendered contract with the required clauses and we'll get this done real quickly with an invoice and it'll save us both time. Can't do that. Obviously, the Office of the Inspector General would be very interested in something like that. So it should go without saying, but I'm saying it here. This should be done in good faith. Next slide, please. So we talked about those. We talked generally in the outline of the nuts and bolts of the procedures about the three acquisition methods. The first being GSA area-wide contracts. So what are they? GSA area-wide contracts provide a pre-established contractual vehicle for ordering utility services. And they provide for ordering a utility service at rates approved and or established by a regulatory body and published in a tariff or rate schedule. Although agencies are permitted to negotiate other rates in terms of conditions of service with the supplier. And you can obtain a list of these GSA area-wide contracts through your GSA regional offices or through the GSA's energy division, and I listed their webpage and their email there. Next slide, please. And it turns out that the GSA area-wide contracts method of these three methods, the GSA area-wide contract, a separate contract, and third, an interagency agreement. Turns out GSA area-wide contracts really are contemplated by Part 41 as being the default method. Part 41 says that any federal agency having a requirement for utility services within an area covered by an area-wide contract shall acquire services under that area-wide contract, unless, and it gives a couple of exceptions, if service is available for more than one supplier, or the head of the contracting activity or designee otherwise determines that use of the area-wide contract is not advantageous to the government. And you have to document, as the FAR goes on to say in section 41 or FAR 41.204C1, you have to document that determination, that not advantageous determination. But the bottom line here is that the GSA area-wide contracts are really supposed to be the default way of procuring in terms of the actual nuts and bolts. Next slide, please. So how does it work? How does it actually operate these GSA area-wide contracts? First, you've got to get an authorization form for ordering the service, the connection, disconnection, or change in service. You get that authorization executed by the contracting officer and the utility supplier. And the utility supplier is then required to furnish at the applicable rate the utility services to be provided. The CO then needs to execute the authorization and attach it to SF-26, along with any modifications such as connection charges, special facilities, or service arrangements. And then the final bullet point there, I list here that any specific operational, administrative requirements, applicable rates, drawings, basically the specifics that have to be added on to the area-wide contract and the authorization need to be incorporated. Next slide, please. So what's the second method of the three? The second method is the separate contracting method. So the rule is, in the absence of an area-wide contract or interagency agreement, agencies shall acquire utility services by separate contract. And the contracting officer has to provide certain information that's set forth in FAR 41.205B. And the year limitations here, it says contracts between 1 and 10 years may be justified and are usually required where any of the following circumstances exist. Either the government is going to obtain lower rates, larger discounts, or more favorable terms and conditions. There's a proposed connection charge, termination liability, or other facility charge to be paid by the federal government that will be reduced. Or the utility service supplier, and this is probably the one that will get many in, the utility service supplier refuses to render the desired service except under a contract exceeding a 1-year period. Next slide, please. And the main point there from that slide, by the way, is you first need to show as the federal agency, and you can expect as the supplier, that interagency agreement and GSA area-wide contracts are either not available or not appropriate under the relevant standard. But what's the third method? Interagency agreement. Interagency agreements, agencies shall use interagency agreements, consolidated purchases, joint use, or cross-service agreements when acquiring utility services or facilities from other government agencies, and shall comply with the policies and procedures at FAR 17.502-2, the Economy Act. Generally, that requires a formal agreement, and it requires a series of determinations and findings that are set forth in FAR 17.502-2. That's outside the scope of this presentation, but you can see what those determinations and findings are. So let's say FAR 17.502-2. Next slide, please. So we talked in the outline about requests for assistance from GSA. GSA is the primary acquirer of utility services, but it delegates its authority. But even when it delegates its authorities, it can provide technical assistance in the acquisition of utility services. So how is this done? Well, first, the federal agency needs to request assistance from the GSA, in which case GSA will provide technical and acquisition assistance or delegate its contracting authority for the furnishing of the services described in this part for any federal agency or mixed entity. Then it gives several other federal arms. The request has to be submitted to the appropriate office, and requests for delegations of authority from GSA or for assistance with a proposed contract have to be submitted to the appropriate GSA regional office where service is required. And also the request for assistance needs to be timely, which means not later than 120 days prior to the date new services are required to commence or an existing contract will expire. And the request has to contain various information that's set forth in FAR 41.301B, C, and D. Next slide, please. So we also mentioned in the outline that we would discuss a few administrative points. And the first is monthly and annual reviews. So the acquiring federal agency must review the utility service invoices on a monthly basis, but it also has to review utility accounts on an annual basis, at least to the extent that those exceed, the accounts exceed the simplified acquisition threshold on an annual basis. But that doesn't rule out annual reviews of accounts, even for those below the simplified acquisition threshold. Those should still be, according to the FAR, conducted when deemed advantageous to the government. So what do these involve? Because they serve different purposes. The monthly review is just of the invoice, and obviously is just to ensure the accuracy of the monthly invoice. But the annual review, which is the review of the entire utility account, is much more in depth. And the purpose is to ensure that the utility supplier is furnishing the service to each facility under the utility's most economical, applicable rate, and to examine competitive markets for advantageous service offerings. And it's got to be based on the facility's usage, conditions, and characteristics of service at each individual delivery point for the most recent 12 months. Importantly, if a more advantageous rate is appropriate, the federal agency shall request the supplier to make such rate change immediately. So this is not a pro forma, perfunctory annual review. It actually should have some teeth in it. Next slide, please. So that brings us to rate changes. So what happens with rate changes? Where changes are proposed to rates or terms and conditions of service, the agency shall promptly determine whether the proposed change is reasonable, justified, and not discriminatory. If the change may be of interest to other federal agencies, an intervention before a regulatory body is considered justified, the matter shall be referred to GSA. And the agency may request from GSA a delegation of authority for the agency itself to intervene on behalf of the consumer interests of the federal executive agencies. So the important point here is that the federal government, through the GSA or delegated through an individual federal agency, can actually itself intervene in a state regulatory body's proceedings involving rate changes and rate challenges. And the FAR expressly recognizes this, although it has a process for how it's to be done, how it is to be done. First, you should go to the GSA, and of course the GSA may actually delegate upon request that authority to the individual agency, the federal agency. So if a regulatory body approves a rate change, it has to be made part of the contract by unilateral contract modification or otherwise documented in accordance with agency procedures, and it's effective on the date determined by the regulatory body, and resulting rates and charges shall be paid promptly to avoid late payment provisions. Next slide, please. So another point on rate changes and regulatory intervention. Where the utility supplier is not regulated and the rates, terms, and conditions of service are subject to negotiation pursuant to one of the required clauses that applies when the utility is not regulated, any rate change shall be made part of the contract by contract modification with copies sent to the agency's paying office or office responsible for verifying bill amounts. So basically, for unregulated utility suppliers, those rate changes are much more normal in their process. It can be done just through basic contract modification. Next slide, please. So we're going to talk generally about solicitation, required solicitation provision and contract clauses. We're not going to go too far in depth into each of them. We list them in a slideshow, which is available for you to study. But before we dive into this, just recall that there is that scenario where the federal agency presents the utility supplier, tenders it with the contract containing these provisions, and the utility supplier refuses to agree to it. And so some of these, or potentially all, might not actually be a part of the contract. And for a federal procurement lawyer or a federal government contractor, this is sort of bonkers, to use a not so legal term, but it is possible. So we're going to talk about these and we're going to list them, but just keep that sort of odd scenario in mind. So here we're listing all of the required contract clauses that are required regardless of whether whether there's some specific provision in the clause that that would otherwise render it inapplicable. You've got the first clause, which is compliance representation relating to proposals from alternative electric suppliers being sought. You've got order of precedence, you've got scope and duration, change in class of service, contractors, facilities, and service permissions. Next slide, please. Then you have a series of required contract provisions that will apply if the prescribed conditions warrant doing so. So first, for regulated service providers, there's a specific clause relating to changes in rates and terms and conditions. Then you have a clause that's required to be inserted into the contract for unregulated utilities and services that discusses changes in rates or terms and conditions. And then you've got connection charge, when a refundable connection charge is required to be paid by the government to compensate the contractor for furnishing additional facilities necessary to supply services. You also have a provision for termination liability when payment is to be made to the contractor upon termination of service in conjunction with or in lieu of a connection charge upon completion of the facilities. Next slide, please. There's three more of these sort of contingently included contract clauses. One is multiple service locations when providing for alternative service locations except under area-wide contracts. You've got an additional clause for non-refundable, non-recurring service charges when the government is required to pay a non-refundable, non-recurring membership fee or a charge for initiation of service or a contribution for the cost of facilities construction. We also have a contingently included clause for capital credits when the federal government is a member of a cooperative and is entitled to capital credits consistent with the bylaws and governing documents of the cooperative. Next slide, please. So to take a select clause, and I chose this one, a required clause, because I thought there were a lot of interesting elements to it, is the changes in rates or terms and conditions clause for regulated services, and many, if not most, of the services are going to be regulated. So first, you'll see in subparagraph A of this, the actual text of the clause, which can be found again in 52.241-7, it's a notice provision when there is even an application for a change in rates or terms and conditions. It says the clause will require the contractor to agree to give the federal agency, whoever it is, written notice of, one, the filing of an application for change in rates or terms and conditions of service concurrently with the filing of the application, and two, any changes pending with the regulatory body as of the date of contract award. And it has a bunch of requirements. It's got to fully describe the proposed change, the regulatory body having jurisdiction, whether it's approved. The contractor has to forward it to the contracting officer within 15 days after the effective date thereof. So there's a lot of stuff in here regarding notice. And this may be different. You'll see this on the next slide. This may be different than state regulatory requirements regarding notice. And that's the point I'm trying to draw out here, is that this may go beyond what the state regulatory body requires, and you've got to abide by this. Subsection B says it includes a most favored nations clause. It can't be in excess of the lowest cost published and non-published rate schedules available to any other customers. I thought that was worth calling out. Subsection C says, in the event that the regulatory body promulgates any regulation concerning matters other than rates which affect this contract, the contractor, the vendor, has to immediately provide a copy to the contracting officer. That's important. State regulatory bodies routinely promulgate regulations concerning matters other than rates that could potentially affect the contract. And this is saying that the contractor has to give immediate notice to the contracting officer, the federal government's contracting officer, of such regulation being promulgated, even though it doesn't have to do with the rate. Next slide, please. That was the full text of that FAR contract clause provision, by the way. This slide, I'm just giving you a reminder here that those notice provisions may differ from the state regulators' notice provisions, and in two ways. One, it may be more onerous, but potentially, at least, it's possible that the state regulators have more onerous notice requirements than what the FAR provides. What's the answer? Comply with the most onerous. At least comply with the FAR, but if the state notice requirements would exceed that, you should also provide whatever notice requirements, and I say you, the utility service provider, would have to, if they're smart, would comply with whatever are the most excessive. Next slide, please. So finally, we're going to discuss very briefly just the forms and formats. So in terms of forms, Part 41 says that unless you're using an area-wide contract, a purchase order, or an interagency agreement, agencies must use SF-33, solicitation, offer, and award, SF-26, award contract, or SF-1447, solicitation contract. And the contracting officer must incorporate the applicable rate schedule in each contract, purchase order, or modification. And as to the formats, the format provisions of FAR Part 41 state that the contracting officer should obtain specification formats for the following utility services from GSA: electric service, water service, steam service, sewage service, natural gas service. So if it's any of those utility services, remember there can be others, the contracting officer should obtain a specific format from GSA. Next slide, please. Now, just because you can obtain those formats doesn't mean they can't be modified. Contracting officers, according to Part 41, says that contracting officers may modify the specification format and attach technical items, details on government ownership of equipment and real property and maintenance or repair obligations, maps or drawings of delivery points, and other information being necessary to fully define the service conditions. And again, this is consistent with what we saw earlier about incorporation of specific details that have to be incorporated. Specifications and attachments must be inserted in Section C of the Utility Service Solicitation and Contract, and that's under FAR 41.701C. But as it goes, as it relates to forms and formats, it's pretty straightforward. You've got the relevant FAR provisions there and who you should reach out to in order to get your starting point forms. Next slide, please. So that's it for Part 41. Again, my name is William Stowe. I'm a commercial litigator, but I also practice extensively government contracts, federal government contracting, state government contracting. I do it all over the country and at every stage of procurement. If you've got any questions or just want to reach out and make a contact, I'd be happy to speak with you, and I appreciate your time.
Thank you again, William, for an informative presentation, and thanks to everyone for joining us. As mentioned, you can always catch the recording on our YouTube channel within 24 hours and find over 600 webinars on government contracting there. That's it for today's webinar. Thank you again, William, and thank you everyone else. We hope to see you tomorrow.